About how the court works. And we're looking at judicial procedure. So basically, if you find yourself in court, what does that mean? And particularly, we're going to be talking about how the Supreme Court works, because after all, these cases that you're studying changed our country in a big way. And so let's look at how it works and what that means. So first off, the Supreme Court meets each year for 9 months at a time. During this time, they hear cases. These cases have been pre-planned and added to the docket. A docket means the court's calendar. So you can look online and you can find out what cases the Supreme Court is going to hear between this coming October and the next July. Cases can only be added to the court's docket if the court, if that is, at least 4 out of the 9 judges agree that it needs to be added. So for example, let's say that someone wants to reinterpret free speech to say that an offensive banned t-shirt should now be banned. Well, they've already ruled on that. They've already made that decision. They don't need to decide on that again. And so it's not going to be added to their docket unless 4 judges say, well, no, what the case they have is compelling. We need to hear it. Okay, so let's assume that your case has been accepted. Maybe you got in trouble for something you don't feel like you should have gotten in trouble for. Maybe it's not just a you versus the school case, but it actually represents something deep and fundamental about our country, something constitutional. Well, then they may decide to hear it. And if 4 out of the 9 judges decide to hear it, congratulations, you are now arguing a case before the United States Supreme Court. It's an honor. Something that people work their whole careers and they never get to do. And so again, you only get to bring your case to the United States Supreme Court if it is a significant, fundamental constitutional question. And of course, it has to deal with real people or real things that happen. You know, Dred Scott versus Sanford, that was a slave, and it's one of the cases you can study, who lived in a slave territory and his owner died. Well, it was a territory, so it was a bit of a nebulous question. It had not yet been decided should they technically allow slaves or not. And so when the owner died, a group realized here's the chance to challenge slavery. We've tried to challenge it. The president wants nothing to do with it. We tried to challenge it. Congress wants nothing to do with it. But what about the Supreme Court? And so again, it dealt with a real person because the Supreme Court ruled that Dred Scott needed to be sold back into slavery. The Supreme Court is supposed to be above politics. And so they're dealing with legal issues. They're not going to pass a law ending slavery, but their ruling has the power of law. But they are interpreting existing constitutional amendments and articles to determine if they fly or not. So what types of constitutional questions might they be looking at? The most common you're going to hear about is freedom of speech. Because again, speech is a rather complicated thing. Does that mean something that you post on social media? Does that mean a text message that you send someone privately? What constitutes speech? Also, equal protection under the law. Equality is something you think we could all take for granted and understand equal means equal. But it's not that simple when it comes to applying the law equally. It's actually really hard to treat people equally because we naturally have prejudice that are just innate in our character. We look at someone and within seconds we decide whether that person is attractive. We decide whether that person is trustworthy. And within few moments we decide whether or not we want to engage in conversation, To what degree do we want to connect with this person? All of those things are natural prejudice that can hinder equal protection under the law. And so that case has been brought up many times. But also even a fair trial. What does that mean to receive a fair trial? The devil's in the details, and the interpretations have been many throughout the court's history. Okay, so how does this work? Number one, let's assume that you have received a writ of cretoria. That means the Supreme Court's going to go through a number of steps. First off, there are going to be written arguments. You can follow a Supreme Court case. You can read about its history from the beginning of the case until the end of the case, because all of its proceedings are in writing. When arguments are delivered, they're not just fancy speeches in a courtroom. They are actually written briefs that the panel of judges study and advance to the case. And of course, during the case, oral arguments will be written. They'll be transcribed for posterity, but they'll be delivered in person. That means the person arguing the case is actually going to go before the panel of judges, and they're going to plead their case. You know, we need to reinterpret free speech now that text messaging is a thing. Or perhaps when a new technology that allows us to telepathically communicate with one another could happen. We will now have to figure out how free speech works within telepathy. I don't know the answer. Someone will eventually have to figure it out. And that will be made, again, through written arguments, through oral arguments, and then finally, the judges will have to talk to one another. Meaning that they will close the court, they'll have their own private meeting, and they will decide amongst themselves how to rule on the case. For example, in Brown versus Board of Education, the lawyers representing the young students that wanted to attend an all-white school first provided a written brief of how they believed that segregation was a violation of the 14th Amendment, and how that the court needed to rehear the case that they had originally ruled on from Plessy v. Ferguson. And so first, the judges added the case to their docket. 4 out of the 9 agreed. At that point, which they read the written arguments from the plaintiff claiming that these students should have the right to attend this school in Kansas and Topeka. And then they made their oral arguments, meaning that the person representing the students came and argued before the Supreme Court, and then the justice said, okay, we've heard everything we need. Y'all go home. We'll talk about it. We'll come up with a decision in their conference. And the exciting part. Unless you're a lawyer, court proceedings are not always the most exciting thing, but the really cool part is that you can go back into each one of these cases and you can read the opinion. And the opinion is what really matters. That's basically the new ruling that has the power of law. And often there will be a majority opinion, which is what the Supreme Court has agreed to, and often there will be a minority opinion, meaning not all judges agree. Some cases all of them agree, not always. And then finally, it will be announced. And for example, in Brown versus Board of Education in Topeka in 1953, the Supreme Court ruled that segregation creates a situation in which students are treated in an inferior way. Ergo, separate but equal does not work. And if we are to apply the 14th Amendment in the appropriate manner, schools must be integrated. And that was announced in 1953. And the rest of the 1950s and 60s, rather, were the process of making that happen. Now, during the case, each position will prepare a brief, a summary of what their position is. When we had that debate, the first round, you guys prepared your brief, your summary of why it is you feel the certain way that you do. The first round, you then made your arguments, and of course then the judges met, and our decision was finally reached. Now, if you ever do read a Supreme Court opinion, it's actually a number of different documents. For example, just like I said, the first one that you're going to read, really the important one, is the majority opinion. Let's say you want to study abortion. You're wondering, hey, why is this a thing? Go back to Roe v. Wade in 1979, and you can read the court's majority opinion. And you can read the reasoning for why that was legalized by the U.S. Supreme Court. However, there was also a minority opinion. And we'll get to that in just a moment, but first I want to talk about a concurring opinion. A concurring opinion is a statement written by a justice who sided with the majority, but for reasons different than what the others felt. So perhaps a justice went along with the majority of the other judges, but he needed to make a point for posterity. So he still voted and sided with the main group, but he had reservations and he wanted to point those out. And so he's going to put those in writing in a concurring opinion. And so maybe in Roe v. Wade, one judge ruled for abortion, but had differing reasons for ruling for this than others. And so that's a written document that you can read. And then next, and if you like drama, this is the fun part, these judges often disagree. And they would present this in writing in what's called a dissenting opinion. And this is where they're going to express their disagreement, why they voted against the others, in writing. And it's recorded for posterity. And that also helps people who are considering challenging the ruling at a later date. So for example, we talked a lot about gerrymandering in here. Gerrymandering is the process by which the party in power in a particular state gets to draw the voting districts according to the way they want. And a lot of people throughout American history have had a big problem with this, because what it effectively allows is lawmakers to pick their voters instead of voters picking their lawmakers. And that's an inherent problem in democracy. We can't get Congress to fix it because they benefit from this system. We can't get the president to do anything about it because Congress will just overrule it. And so the last bastion of hope to end gerrymandering has been the courts. And people have challenged gerrymandering in front of the courts. And one of the justices wrote a concurring opinion that has led people to have hope that this can someday be overturned. And his concurring opinion was, and I'll paraphrase, that right now I have to vote against interfering with the current system. But if you can come up with a better way to do it, we'll hear your case again. And so people think they have come up with a better way to do it. And the Supreme Court just ruled that Pennsylvania had to fix its system. And they did, and they fixed it. And you can check it out online. They've got a new system they had to go by that was drawn by a nonpartisan commission. And that was the method that finally the Supreme Court agreed to. Now, it wasn't unanimous. A unanimous opinion means that all of the justices agree, and which sometimes happens. And then, of course, announcing the opinion is the exciting part. All right, so the Supreme Court has reached a decision. Now, what does that mean? Okay, so what factors can influence this type of decision? Well, number one, the Supreme Court is built on the idea that the law is the foundation of our government, that our government is subject to the law, and that the people are involved in making the law. And so that means that precedent which is an important part of our law, will also be used in consideration. And the Latin term for that is stare decisis. And that means that earlier rulings will be used as the basis for modern rulings. It means, literally translated, let the decision stand. So for example, we're really learning as we're going with the contacting our representatives, but we're establishing a lot of precedents in here. For example, it's been efficient for you guys to work in the same group and to continue to communicate in the same group even though we're getting new groups each week. That's a precedent that we're establishing that I'll probably use. So from now on, future civics classes, one group will be the state representative group until we get that person in here. And that's a precedent. And according to stare decisis, we're going to continue to use that until perhaps we find a better way. Another example of law is the foundation. Like many of you guys said when we were talking about interpreting the Constitution, the law needs to be able to adapt. And the Supreme Court needs to be able to adapt too. So that means that this ancient document written in 1789 will occasionally need to be reinterpreted, even if it doesn't change. The words, the very nature of the words might change. Equal, what does that mean? And again, that will need to be interpreted through the changing times. And that gives the Supreme Court the opportunity to overrule a previous decision. Because after all, the Constitution is not always clear. For example, the case of Bush versus Gore. Does the Supreme Court have the right to interfere in an election? Well, there's a precedent for it. In 1800, there was a case where Congress could not decide who should be president. There was a tie in the Electoral College. Can you imagine if Trump and Hillary had tied? I mean, oh my gosh, right? There might have been people burning down cities if Trump and Hillary had tied. There might have been people killing one another. Well, now imagine what if two candidates tied in a country that was just getting started, right? Countries fall apart over that sort of thing. And so in 1800, Congress voted 32 times to try to come up with a winner for the president. 32 times they could not. Alexander Hamilton changed his vote. The loser challenged him to a duel and shot him dead. And that's how we wound up with Thomas Jefferson as our third president. Perhaps, had the Supreme Court intervened, it wouldn't have turned out that way. Fast forward 200 years. In 2000, George W. Bush won, but lost the popular vote. The Electoral College came to almost a dead tie again, but it really came down to the state of Florida. The manual recount was beginning, and the Supreme Court put a cease and desist on the recount and declared Bush the victor. And so there are cases where the Supreme Court has declared a victor. And that's one of the. Okay, of course, the issue of segregation was decided in the Supreme Court. First in Plessy v. Ferguson in 1896, Homer Plessy sued to gain the right to sit in the front of a train. And the Supreme Court upheld the ruling of a previous lower court and decided that Homer Plessy did not have the right to sit in the front of the train because of his skin color, which of course, as we know, was famously overturned in Brown versus Board of Education in Topeka, Kansas. the irony is both cases used the 14th Amendment as the law they were interpreting. And two different courts interpreted the same words in two different and profound ways. Plessy v. Ferguson meant that the court was not going to intervene in the South or interfere with Jim Crow. Brown v. Board meant, oh yes, they were. And so this means that the same law can be interpreted in different ways, and that yes, personal beliefs do factor into this.